like we've got 8 in the room.
Okay. It is 12:03 on Tuesday, February the 27th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Davis, Fritz, Gillespie, Hardaway, Howell, Halsey, Johnson, Lamberth, Moody, Russell, Towns, Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you, ma'am. Members, do we have any personal orders before we begin? I will take some personal orders here. I've got Zach Moffitt and friends from Pulaski, Giles County that are with us today. So please help me welcome them. Representative Hardaway.
Thank you, Chairman. Do we have some Memphis folks in here, Shelby County folks? Y'all holler out real loud, the organization for me. Free the vote. All right. All right. So if y'all would make them welcome, Mr. Chairman, free the vote.
Any other members? We'll go to our Sergeant of Arms, Mr. Tyler Muniz, for the weekly words of wisdom.
Good afternoon, everyone. Today's words of wisdom are brought to you by Morgan Freeman. If you want to see a miracle, be the miracle. Have a great day.
Thank you, Tyler. All right, members, one quick announcement for those that are members of the House that are watching this or on the committee. I want to encourage you to ask your Senate companions to be putting those bills on notice and get them moving through the process. We called last calendar for this committee last night. And so last calendar is March 26th for here. So that's our last calendar for criminal sub. So encourage your Senate counterparts to get those on notice. All right, we've got a lengthy calendar, so we're going to get started. If you'll go with me to item number 23, House Bill 687 by Representative Freeman will be rolled 1 week. Item number 28, House Bill 1981 by Representative Jones, roll 1 week. Item number 34, House Bill 2514 by Representative Harris is off notice. And item 35, House Bill 2518 by Representative Harris is off notice. Brings us to item number 1, House Bill 1920 by Leader Lamberth.
Motion. Second.
You're recognized.
Thank you, Mr. Chairman. Very straightforward bill. It just gives general sessions judges more flexibility on percentage of time served by individuals convicted of misdemeanors.
All right. Thank you for the explanation. Any questions from the members of the committee?
Question on the bill.
Representative Hardaway.
I withdraw.
Thank you.
Thank you. I think I understand. I just thought they already had that discretion.
No, sir, they do not. It is capped out at a certain percentage of the sentence. They can go from 0 to 75% of a sentence. They can't go beyond that. And I just think that's best left in the hands of the local judges that are elected for their communities and the sheriffs and the district attorneys and the public defenders and everything else. This just says it's 0 to 100%. They can pick whatever percentage they want to for release eligibility based on the programs they have available in the jail, based on the individual for them, their specific needs, all of that.
So it in effect expands judicial discretion.
Yes, sir, that is correct.
And that's a good thing.
Yes, sir, that is correct.
Thank you, Leader.
Any other questions for the sponsor, Representative Johnson? Sorry.
Thank you, Mr. Chair. I'm just curious, it seems like this would require, a little more time. Incarcerated, does it not have a fiscal note?
It does indeed have a fiscal note, and that fiscal note is not significant.
Thank you.
Any other questions? Questions called. Any objections? Seeing none, we're voting to send House Bill 1920 to full criminal. All those in favor say aye.
Aye.
Those opposed? The ayes prevail. You
Thank you,
move
Mr. Chair,
forward.
members of the committee.
Item number 2, House Bill 2099 by Representative Cochran. You are recognized.
Thank you, Chairman and Committee. So House Bill 2099 essentially sets up a fund for district attorneys, be used for support services to promote public safety, such as specialized training in child abuse, domestic violence, sexual assault prosecution, as well as funding expert witness testimony. This is replacing an older fund that used to be collected from cases involving bad checks, but obviously that doesn't occur too often any longer. So this is replacing that fund at the county's discretion. With that, I will yield any questions.
You've heard the explanation. Any questions for the sponsor? Seeing none, we're voting now to send House Bill 2099 on the full criminal. Those in favor say aye. Aye. Those opposed? The ayes prevail. You move forward.
Thank you, Chairman and Committee.
Thank you. Item number 3, House Bill 2168 by Representative Littleton. And no, sir, we're going to roll her 3 spaces. I'm going to hand the gavel off to my chairman.
Motion on the bill.
Okay, we're on item number 4, House Bill 2696. We got a motion and a second. You're recognized, Chairman.
Thank you, Mr. Chairman. I have an amendment code 12227.
Motion on the amendment.
All right, we're voting on Amendment 012227. All those in favor say aye.
Aye.
All opposed, no. Ayes have it. The amendment's on the bill. Please explain.
Thank you, Mr. Chairman. House Bill 2696 as amended creates a Class A misdemeanor offense for a defendant who violate any condition of a pretrial release, clarifies that a person who violates a condition of pretrial release may be arrested with or without a warrant.
All right, that's the explanation of the bill. Any questions for the sponsor? Representative Johnson.
I guess my question is, there was another bill similar to this, which I think was Representative Lamberth's bill. It seems like together they're a little confusing. Can you tell me how they would operate together?
Chairman.
Thank you. Both of our bills are, though they are very similar, they do have some differences. And so if the leader's bill ends up passing on across the finish line, we will eventually amend ours out and leave one section in to complete what we were seeking to do.
And which section would that be and how would it be different?
Tell you what, I've got someone here to testify, Chairman, if you would.
Mr. Crump?
Like, Mr. Crump?
Okay. Without any objection, we're going to go out of session. General, you are recognized. If you please make sure the red light's on and state your name and who you're with for the record.
Thank you, Mr. Chairman and Committee. My name is Stephen Crump. I'm the Executive Director of the Tennessee District Attorneys General Conference and stand ready to answer any questions you may have.
Representative Johnson.
Yes, so some folks thought that it might be confusing between those 2 bills. So I was just wondering if you could tell us what the difference would be.
Certainly, the only difference is the actual revocation. We spoke with Leader Lamberth about these 2 bills and about moving them together simultaneously. The Senate version will not contain that, and once the Senate version moves through, they will send it to you all for hopefully you all to conform, and then the 2 bills will work together so that they won't be confusing. They'll be actually one unified piece of legislation.
Thank you. That was the concern with folks, was that it was confusing between the 2 and what's that going to look like. So thank you.
2 different folks had the same good idea and tried to figure out how to put it together.
The question for the general. Representative Hardaway.
Thank you, Mr. Chairman. Good afternoon, sir.
Hello.
So which one is a better bill?
Whichever one this committee seems to think is the better bill.
Well done, sir.
Any other questions for the general? Representative Towns.
General, that sounded like a Perry Mason answer to me.
It would be the other side of the courtroom potentially, but yes.
Thank you, Mr. Chairman.
Any other question for the general? All right, thank you, sir. Appreciate you being here. We're back in session. Any questions for the sponsor of the bill? Question's been called on the bill. We're voting on House Bill 2696. All those in favor say aye. Aye. Opposed, no. Ayes have it. Moves on to criminal full.
Thank you. All right, members, go with me. We're going to jump in the calendar here. Item number 10. Item number 10, House Bill 1905 by Representative McCalman. You're recognized.
Thank you, Mr. Chairman. Members, really simple bill. All this does is bump up the penalty for willful, purposeful, and injurious child abuse from a Class A misdemeanor to a Class C felony. And with that, I stand ready for questions.
Any questions for the sponsor? Seeing none, we're now voting to send House Bill 1905 on the full criminal. Those in favor say aye. Those opposed? Ayes prevail. You move forward.
Thank you, member and committee.
See, item number 5, House Bill 2590. Roll to the hill. Item number 6, House Bill 688 by Representative Hardaway.
Roll to the hill.
All right, House Bill 688, roll to the hill. Item number 7, House Bill 1718 by Representative Gillespie.
Thank you, Mr. Chairman. I'm requesting this to be rolled to the hill.
All right, that objection, roll to the hill. Item number 8, House Bill 2279 by Representative Hawk. All right, Representative Hawk, you are recognized. There is an amendment code 14385.
Thank you, Chairman. I believe that's your amendment that you'd like to place on it.
It is.
It is
If
a
you
friendly
wish for us to
amendment.
proceed, then it's a friendly amendment. All right, you reckon we are, we're on the amendment. Let's vote to attach amendment code 14385 on the House Bill 2279. All those in favor say aye. Aye. Those opposed? Ayes prevail. You adopt. We're on your bill as amended.
Thank you, Chairman and members. The bill really does what the summary states. It authorizes a judge, when taking into account the facts and circumstances surrounding a delinquent act, to order a juvenile who has been adjudicated delinquent for the rape of a child to register as a violent juvenile sex offender in cases which the victim is less than 4 years younger than the offender, rather than only when the victim is at least 4 years younger than the offender. Ultimately, this is discretion for a judge to make this consideration, Chairman and members.
Thank you for that explanation, and I will make a point here. The amendment that we just adopted on here adds a date that says in section B there for acts occurring on or after July 1 of 2024. And so that's the change that we made with that amendment, as we put a date on there. Any questions for the sponsor on the bill as amended? Chairman Halsey.
Yeah, do you have any idea how long on the registry they would remain?
And as described to me, and I'm learning about the registry as it affects juveniles, the juvenile registry is not a public registry. It is something that they would go on to until they reach the age of majority. And then if all behavior is fine after that, then they can be removed. If their behavior persists, then that would fall more in line with the adult sexual registry that's out there. But at this moment, it would not be public unless they continued bad actions. Thank you.
I believe the age is to the 25th birthday unless they reoffend. Mm-hmm.
And thank you for that. I probably did not clarify that well enough. Thank you, Chairman.
Yes, sir. Thank you. Any other questions for the sponsor? Representative Hardaway.
Thank you, Chairman, and it might be for the chairman instead of the sponsor. For the access to this particular registry, is it law enforcement, judicial, the DAs? Who has access to that registry?
Chairman, I could take a swing at that. The registry does eventually become public, but there may be someone for the TBI who can answer that better than I can. I'm not sure who else on the list, Chairman.
We do have someone with TBI here, Representative Hardaway. If you would like to, I could give you an answer, but it would not be the 100% perhaps correct answer. So
Yes, sir. I'd like the 100%
Okay.
since it's about juveniles.
we will, yes, sir, we'll go out of session. Hear from Miss Rachel Russell with the TBI.
Mr. Chairman, have we heard from her this year?
I think this is her first time back, Representative.
Yeah.
Good morning. Good morning, Chairman.
Good morning.
Good morning. Rachel Russell, TBI, I'm Deputy Counsel of Policy. And admittedly, it is a confidential registry. It has been a little bit since I've had to look in the registry yet since I have moved into this role. I might defer to legislative legal, but it is a confidential registry that is not available to the public. It's law enforcement sensitive.
So would that be law enforcement and the courts, the DAs, or just law enforcement in the pure sense?
So it is confidential. And again, I do not remember if the act goes in further, and I'll defer to legislative legal. I don't think that it does. I know as far as who has access to that information, the way that it is set up, the registering agencies have access to get into the confidential registry. The district attorney would have access to that if they violated the act, because they would be able to file that violation if you have a juvenile that ends up violating the registry. But again, it's a confidential registry, and I believe that is as much detail as the act itself gives.
Okay, Mr. Chairman, unless there are other questions for Ms. Russell, I would like to have our legislative legal weigh in also.
All right, Representative Towns, you want to ask a question before we ask legal, or you want to hold it? Okay. We'll go to legal services for that inquiry.
Michelle Fogarty, Office of Legal Services. I would agree with Ms. Russell that there's nothing, the juvenile record is confidential. It doesn't state in the statute who has access to it. It just states that it is confidential. There is another statute about providing information that is made public to the United States Attorney General, appropriate law enforcement agencies, including probation and parole offices, as well as school and public housing agencies. That's in 4039-214. But again,
And-
as far as juveniles are concerned, the registry is not public, it is confidential.
And does the proposed legislation or existing statute speak to penalties for revealing or breaking the confidentiality, revealing that information?
The bill before the committee does not address that at all. It does not speak to that. And the statute that is being amended by this bill also does not speak to that.
All right, thank you. Thank you, Chairman. Thank you, Ms. Russell.
Yes, sir. Representative Towns.
Mr. Chairman, thank you. As it relates to the confidentiality, does that extend to the 25-year age of that particular offender? If they kept on the registry for 25 years,
They stay on their,
No, go ahead.
either one.
I'm going to ultimately, I think, pass it back to Ms. Fogarty as well. They are allowed to request termination at the age of 25. And again, it's been a little bit since I've been in these statutes, but there is language within the act that discusses the 18th birthday in the confidentiality. If I'm remembering it correctly, and I'll let legal correct me, I believe that it only becomes a public record at their 18th birthday if they have reoffended. I believe that's the triggering event, is if they reoffend. So if they are found adjudicated delinquent of another offense, they still stay confidential, but it's at their 18th birthday is when it actually becomes that. They move on to the public website. So to answer your question, as you've asked, they would stay on that confidential registry until the age of 25, unless there's another incident.
Okay, all right. Thank you.
Representative Towns, you good? Representative Hardaway?
Thank you. And Rep. Towns brought up the point of whether another triggering event would kick it into the not necessarily the public sphere, but would remove the confidentiality. Would that event have to be after they leave the juvenile jurisdiction? Does it matter whether it's as a juvenile or as a adult?
It would be in either situation. So if they are adjudicated delinquent a second time, it would also pop them onto that public registry once they turn 18.
Okay. Do we have any other situations where juveniles are on the public registry?
Not unless they, no, not unless they reoffend. There would be no other situation in which they would go onto the public registry.
Okay. And this is stretching just a little, Mr. Chairman, if you bear with me, but would a juvenile who was transferred to the adult courts have their information available to the public?
Yes, so that is going to be different because your violent juvenile offenders by definition, which it's the violent juvenile offender is the definition that's being amended with this bill. That deals specifically with those juvenile offenders that that are adjudicated delinquent. And so if the individual is transferred over to adult court and they're actually convicted of the offense, and again, I'm going to let legal correct me if I'm remembering this incorrectly, but if they are ultimately transferred and they're convicted, I believe that they pop on over. But I'm thinking I may be remembering this incorrectly, so I will let legal correct me. But I believe that the violent juvenile offender is limited strictly to those that are adjudicated delinquent in juvenile court, and if they're transferred over, it moves on to the public registry. But
And I'm ready to go to our staff legal, Mr. Chairman.
All righty.
Michelle Fogarty, Office of Legal Services. Ms. Russell's correct. The violent juvenile offender is a person who's adjudicated delinquent. So that would not apply to a person who's been transferred to adult court and tried as an adult.
So would the juvenile who's been transferred to adult court have their information on and I'm making this term up, the adult registry?
yes, so their information would be available on the public-facing website.
All right. Thank you to both of you. Thank you, Chairman.
Thank you. Any other questions for our guests or legal services while we are out of session? Seeing none, we'll go back into session. Thank you. All right, we're back on the bill. House Bill 2279 is amended. Any questions for the sponsor? Seeing none, we're now voting to send House Bill 2279 as amended on the full criminal. All those in favor say aye. Those opposed? The ayes prevail. You move forward.
Thank you, Chairman, members.
We'll come back to item number 3, House Bill 2168 by Representative Littleton. We're going to roll that one to the hill. All right, we'll come back to item number 9, House Bill 1624 by Representative Sapicki. You are
House Bill 1624 is a bill about empathy for our fellow man or woman. It enacts Brittany's Law, and you'll see the personal connection here from one of my constituents in a short manner here. It creates a Class B misdemeanor offense of knowingly failing to seek medical assistance for an individual who the person knows or reasonably should know is experiencing a drug overdose. It authorizes a sentencing court to order the defendant to complete a clinical substance abuse assessment and participate in a substance abuse treatment program licensed or certified by the Department of Mental Health and Substance Abuse Services, including aftercare recommended by the treatment program. Mr. Chairman, we do have testimony from one of my constituents back home. I can fill in more of the details later, but I would request for time if we would allow those who want to speak first.
Absolutely. Thank you for that. Members, we'll go out of session. Jessica Francis. Welcome. You'll have, if you will, introduce yourself for the record.
Yes, my name
And then
is.
you'll have 3 minutes for your comments. And another thing, members, I've got to tell you, we've got a handy dandy kitchen timer that we're using now because a lot of times our guests don't hear the cell phone when it goes off. So Miss Emily's got the timer set. So when you start, we'll hit go.
Okay, perfect. Okay, my name is Jessica Francis, and I'm here today to testify as why Brittany's Law should take effect. In Tennessee, there are only a few options when someone is overdosing. The first option, which you think everybody would choose, would be to administer Narcan to save their life and to call EMT or to call EMT and use the Good Samaritan Law. The Good Samaritan Law keeps people from getting any repercussions for calling and seeking help when someone is overdosing. But unfortunately, many people who are overdosing or in the room with someone else who overdoses does not choose that option. They choose the option to let them die and or not seek any medical help. Ben Grooms was dying while his friends continued to get high in the same room of his lifeless body. Nobody was held accountable for that. And let's not sugarcoat it, 3,813 people died in Tennessee in 2021, which I'm sure this year the numbers are tripled. Any person that is willing to let someone else die needs to be held accountable. I am not here to judge the addict. I myself have 6 years in recovery. I run a sober living. I try to help these women every day for what I couldn't do for my sister. My sister passed away on June 12th, 2023. My sister died while laying in a camper for hours. 10 other people were there and no one sought help. They found her cold, dead body, cleaned up the room, and called the police. This law would not only hold others accountable for their actions, it will help give some of us justice. So many of us have lost loved ones to an overdose who had no justice. It is hard, and as I do understand the pain of loss without justice or reason, I understand that it is also very hard to charge someone with murder due to the amount of evidence that is needed. Brittany's Law would be a little more simple to hold people accountable for their actions. We would just have to prove that they were there and did not offer help. I may never get justice for my sister's death, but this law would make sure that not only her death, but many of other deaths will not be in vain, and this will also help prevent other needless deaths from overdoses. The fentanyl crisis right now is tremendous. A lot of these people who are using these drugs don't know they're using fentanyl, and they're dying. Narcan is readily available. Murray County has it for free at the health department. I see people all the time on Facebook saying, if you don't have any, I will get you some. I've posted that on my Facebook personally. If you don't have any Narcan, let me know. I'll get you some. I'll drop it off wherever you like it. I think people should be held accountable. And if you are going to let someone die, where's your humanity? Where is your ability? And it's not a strict law. It could even get them help. Like they could go to rehab instead of going to jail, and that's fantastic. Sometimes we just need that help.
Thank you, Ms. Jessica. Our time is up. Members, do we have any questions for her? Representative Hardaway.
Thank you, Chairman. No questions, but I appreciate you being here. Appreciate the courage that it takes for you to sit there and provide the insight to us. I could hear the emotion in your voice, but I appreciate the fact that you're willing to step past that and to create a living legacy for your sister. So thank you for being here.
Thank you.
Representative Fritz.
Thank you, Mr. Chairman. And I would just echo my colleagues' words. Thank you for taking the time to do this. Thank you for what I think has probably become part of your life's work to help people. So I appreciate your heart. Thank you.
Thank you.
Representative Johnson.
Thank you, and I appreciate it as well. I have a dear friend whose son lost her son. There were two people in the room also doing drugs with him, but not nearly to the level because he was young. And them not getting help led to his death. I'm going to ask some questions
Yes,
of
ma'am.
the sponsor,
Okay.
not of you. But because there's some things surrounding this bill that I think that were important for us to talk about. But I do appreciate you and I understand the circumstances, and I'm just concerned about things outside of those type of circumstances. So thank you so
Thank
much.
you.
Any other questions for our guest? Seeing none, thank you for being with us today. Next on my list is Elliot Pinsley and Melody Clark. What we'll do, members, is we'll allow each of them to speak their 3 minutes, and then we can ask questions after they finish their testimony. Whoever's going first, if you will, push that little red button and then state your name for the record, and you'll have 3 minutes.
Thank you, Chairman and Committee. My name is Elliot Pinsley. I'm the CEO of the Behavioral Health Foundation in Nashville. We're a policy research center, 501c3, just trying to provide objective information on mental health and addiction issues, and appreciate all the hard work that everyone in this General Assembly has been doing to address the opioid epidemic, which continues to ravage Tennesseans. So the latest data that we've seen is that this was just announced, I believe, about a week ago, but the 2022 numbers is at least 3,826 Tennesseans died from an overdose in 2022. That's still more than 10 lives lost each day. We have the second highest overdose death rate of any state in the nation. Most opioid overdoses can be reversed, as you've heard in the previous testimony, with timely administration of naloxone. Also, Narcan is a name brand. It goes by some other things, Clixado, et cetera. And you really only have 6 to 8 minutes sometimes. If the person has stopped breathing, it's much less than that. This is a very urgent thing. And this is a very difficult situation for bystanders to navigate, especially when a loved one is in a situation where they might be dead within minutes. Bystanders who witness these overdoses are often really reluctant to call 911 due to fear that they or the person they're trying to help may be arrested. While this bill aims to increase calls to 911 by creating a new criminal penalty for bystander inaction, it's well intended. Unfortunately, it's very likely to backfire. This bill would create the nation's first bad Samaritan law and is likely to result in fewer bystanders calling 911 and lead to more overdose deaths, the opposite effects that are intended. Research is clear that fear of arrest keeps many bystanders from involving law enforcement or EMS during an overdose situation. This bill is unfortunately unlikely to create more confusion, fear, and distrust in calling 911, even though, again, it is very well intended. In 2023, the General Assembly expanded Good Samaritan law immunity protections. That was House Bill 75, which is helpful in overdose prevention. Comprehensive immunity protections are the most effective way to increase bystander calls to 911. Where states have really strong Good Samaritan laws, they've seen at least a 15% reduction in overdose deaths, some states more than that. Investing in awareness campaigns via media and education is expected to increase calls to 911, and that would be a really excellent area of future focus for this General Assembly. A 2018 study showed that bystanders were 3 times more likely to call 911 if they knew about immunity protections that were in place. Good Samaritan overdose response laws have been enacted in 48 states, all except Kansas and Wyoming, and Kansas is debating one as we speak. No states, that's 0, have implemented a criminal penalty for bystanders witnessing an overdose. We want bystanders to call 911 as quickly as possible And having to worry about when immunity might apply versus when a criminal penalty might apply is not something we want people thinking about when we're trying to save a life. Thank you.
Thank you. Ma'am, you can introduce yourself for the record and you'll have 3 minutes for comments.
Hi, my name is Melody Clark. I'm from Signal Mountain, Tennessee. Sorry. I lost my daughter to a drug overdose almost 3 years ago. Instead of them calling 911 or doing anything to save her, her body was dumped out behind a school and she was left there to die. The people that were with her that day, they had outstanding warrants. They had, they were criminals, of course, drug dealers, I'm sure. I feel as if they had felt like that they could call 911 and not get into trouble or serve any kind of repercussions just for trying to save her, that maybe someone would have called to try to help her. No Narcan was used. They literally just went and dumped her body out and left her there to die. I feel as if they were told that there would be no repercussions for calling 911, that more people would call instead of being afraid that they're going to go to jail, because so many of these people do have warrants out on them. They've been in trouble multiple times, and dialing 911 brings a whole lot of attention. I myself work religiously trying to get Narcan available in every area of Hamilton County. I have advocated since the day I lost my daughter. I work religiously trying to draw attention, raise awareness to overdose and addiction in every way that I can. But I just feel like this is going in the opposite direction of the Good Samaritan law. I feel like these people need to know that they can call and not get into trouble for trying to save somebody's life.
Thank you both for your time here with us and your testimony. Members, do we have any questions? Representative Johnson.
Thank you, Mr. Chair. So I think what you said, that there is research-based evidence that it is more successful. People are more likely to call when they know that they cannot be arrested.
Yes,
for
that
helping.
that is correct. This is a difficult topic to study sometimes exactly, and a lot of these laws aren't exactly on the books for decades. We're looking at the mid, 2010s for a lot of these states have moved to advance and secure some of this legislation. But when we see Good Samaritan laws that have really clear immunity protections without a lot of loopholes, like in Tennessee, we've been working and we still need a little more work to shore up this one-time overdose limit exception that is part of our law. But when it's clear and you can advertise it, people are aware, they're much more likely to call 911. It is clear. So they've done research and studies and they've confirmed, in a situation where they knew about it versus someone didn't even know that law existed, they analyzed whether someone was more likely. They found it's about 3 times, and actually more than 3 times likelier that someone would call for help if they knew about the protections.
Okay, and that's a relatively new law in Tennessee. So as you're saying, people aren't aware yet.
We've had this law since, I have to look at my old notes, but I think it's since 2015, if I'm not mistaken. And this bill, let's see. Yes, 2015 is when the original Good Samaritan law passed in Tennessee. There was an amendment to that law at the time that created a one-time overdose limit exception for the person that was overdosing, meaning if someone has had an overdose at any point previously in their life and they're overdosing the situation, then they did not receive the same immunity protections when someone were to call 911. Last year, this General Assembly passed an amended version of the governor's administration bill that would have gotten rid of that one-time exception entirely. Instead, what it did was allow local law enforcement and local DAs to apply immunity at second and subsequent overdoses at their discretion.
Okay, thank you. And And for you, again, thank you for coming forward. It's a very similar situation to the prior witness, but your feeling is that people would be more likely to make that phone call if they knew that there were no repercussions for them specifically.
I think so, because I think that if they feel like, I think sometimes they may feel like they're being tricked. Okay, I'm going to call 911. I'm going to try to save this person's life. Thank you. Yes, I feel like sometimes when they call 911, they think they're being tricked. Okay, I'm going to call 911. I'm going to try to save this person's life. And at the end of the day, they're going to go to jail because,
They'll send police.
yes,
whatever.
yeah, because they've had outstanding warrants or they've previously been in trouble for something. So I
Thank
think they would
you.
be more reluctant to call, more hesitant.
Any other questions for our guests? Representative Hardaway.
Thank you, Chairman. And first, my condolences to you, ma'am. That's the most unnatural act in the world, is to have to bury your child. So I really extend my sympathies to you. Mr. Pensley, are there any other states that you're aware of that have modified their Good Samaritan law the way we are anticipating with this legislation?
This would be the first legislation of its kind in the country, to my knowledge. There are no, we did a scan, we looked at all sorts of policy reviews, and have found the only thing that we found anything close to this involves criminal penalties related to not reporting child abuse. But when it comes to overdose response and prevention, there are no laws that we're aware of and we've been able to find in other states that would criminalize a bystander if they did not act.
So you spoke to raising awareness and education and making sure that the users and abusers knew the law. Would that not be the same process if this law was modified with this bill?
Well, that would be creating two different standards. So you would have immunity protections in some situations and then criminal penalties in other situations, when we're trying to move away from the fear of having any kind of criminal charge and focus on saving a life. So the idea is really, let's get someone out there to respond as quickly as possible. And frankly, we want people to know you're not going to get in trouble. I'd love to see billboards put up along the interstates, in communities, in community centers, have signs and posters, hopefully with our law enforcement partners, on that same piece of advertising and material saying, please call us. We're not here to arrest you. We are here to help. I'm on the national leadership for the Police Treatment and Community Collaborative, a group that's been working for a number of years on pre-arrest diversion and deflection, specifically focused especially on substance use disorder and helping folks in overdose situations. And there are amazing programs that we're seeing, some in parts of Tennessee that are working, like quick response teams. We have these overdose response teams. We have naloxone distribution, and working with law enforcement to partner and build trust in communities so that they're more comfortable reaching out for help instead of running further underground.
I'm just not sure if I'm appreciating perhaps your wealth of experience. To me, it would seem as simple as this is what you get immunity if you do the right thing. This is what you get if you don't do the right thing. The right thing being to summon help, to summon aid. So what am I missing here?
The concept of trying to be supportive and not punishing in these situations is the best path. Obviously, the drug dealers, and we're talking about people putting fentanyl and xylazine and other things into the supply, into fake pills. I mean, we absolutely need to look at doing everything possible to hold those people accountable. But in a situation that is literally life or death within a few minutes, the only thing we want people thinking about is calling 911. That's really what we're trying to do. The immunity protection is really the best practice. It's been written into Government Accountability Office, all sorts of big national and state policy documents. And the Good Samaritan law, again, was passed nearly unanimously. Those expansions were last year by the General Assembly. Again, we haven't seen this. This would be the first time anybody has ever tried to add a criminal penalty. And in every person I've talked to, and experts around the country and throughout our state are very concerned that this could actually lead to more overdose deaths and fewer people calling 911.
All right, so I guess it's a new version of KISS, keep it simple. Samaritan. We'll make that the last S. All right, thank you for your work. Once again, my sympathies to you, ma'am. Thank you, Mr. Chairman.
Acronym of the week by Representative Hardaway there. Representative Fritz.
Thank you, Mr. Chairman. Again, thank you for your time, ma'am. I'm so sorry for your loss. I appreciate the effort you're putting into this. And just one quick question for you, sir. So do we have any data that supports, we talked about the discretion to allow the second time offenders, if you will, with some leniency? Has that yielded a result that you can quantify?
Not yet in Tennessee because that law just changed here just back in, I'm not sure even when it went into effect. I'd have to go back and double check, but it went into effect in 2023 and it is discretionary. And what we really need to see for any jurisdictions that where a DA is like, we're not going to prosecute for this, we want to apply the immunity. It would be great to see that in writing. It would be great to communicate that, make sure the police and sheriff's department where applicable are all on board, but I'm not aware of any community that has done that yet. We haven't gotten to the point that we have really done, I've seen targeted education toward Tennesseans that these immunity protections exist. So what we've passed, I think we need to work on how do we make sure we let the public know, and that way we can see a result. We're seeing overdose deaths continue to increase, not as strong of a trajectory as we were seeing earlier, but we still have a way to go. So it's early, but we'll be monitoring and looking for progress.
Representative Town.
Chairman, thank you. Here again, thank you all for your testimony, especially you. How old was your daughter?
She was 28 years old.
28. Does she have children?
She had 3 children.
Oh, wow.
Yes.
It's a heartbreak.
That is the hard part.
That's an eternal heartbreak. Sorry you had to endure that. My question for you is, we're presupposing that if you got a couple of people doing, 2 or 3 people doing that drug, that they have Narcan. Well, how do we know they'll have Narcan?
Are you directing a question? to
Either
me?
one.
Would you like that?
We don't necessarily know that they have Narcan. A lot of the drug users now make sure they have it before they ever start to do whatever drug their choice is of, because fentanyl is being placed into so many things out there. Adderall, the pills coming in daily look like actual pain pills, but they're pure fentanyl. So a lot of people are keeping Narcan on standby. But for those that don't have Narcan, the best thing that they need to know that they can do is to call 911, and that they're not going to get in trouble for trying to save that life.
And EMS absolutely does respond and very often can get there in time to help either continue with administration of Narcan, rest with naloxone, rescue breathing, whatever it may be. And sometimes it's the first time there's an administration of naloxone. So while we would love to see more people out in the community with naloxone access, it's not to the level that we're comfortable with. And we need to continue ramping up those distribution efforts, looking in places like schools, colleges, universities, thinking of fraternity house. Are they going to have this, just on standby? I'm not sure that's true. In communities of people that might be folks that are further along in their addiction and using drugs, it's probably likelier that someone might have naloxone in hand. But we're seeing people die left and right from fake pills the first time they take something, or maybe something they didn't even realize had fentanyl in it.
And I read the horror stories, and I've had an occasion to go over to TBI to see the stuff. And when you're young, you really don't have good judgment at all, because a lot of it's so small. You're young and strong. You can't do anything to me. And it's deadly, absolutely deadly. And obviously, it's an epidemic around the country. Unfortunately, our people have an appetite for drugs and things that hurt us. And then a lot of this stuff is coming from too foreign countries that we know of. And I often say that they really have us targeted by using this stuff at our young people, our children, whomever use it, because it one time can be your very last time with this stuff. It's spooky. Then there's something called carfenol. Are you familiar with that? It's more deadly than fentanyl.
Carfentanil, yes, sir.
Okay. And then I've never seen that. I've seen the fentanyl, but it's spooky. It's really spooky. The question also becomes is that when people are getting high, they're not in their right mind, and the judgment is off. Okay. So you may think somebody, as not as extreme as they are because you don't have good judgment. Even with alcohol, if you go too far, you just gone too far and it's going to cloud this. And I can only imagine this other stuff, but it does. So this is the reason I like trying to encourage people. PSA announcement years ago, we had drunk driving, the kids driving drunk, and we had all the PSA announcement that really drove that thing down. We had to do a lot of work in this country to get that to a level where it is today. You don't hear about it today. So we've done a much better job. This may be a better approach because ultimately what you want to do, you want to save that life, you want to save somebody's life, And I knew from my understanding years ago when it first came out, it was so deadly that even our law enforcement officers were afraid to touch it because I understood you get it seep through gloves and all that stuff. This is the early on stuff. So it's tough, but you want to try to do what's going to encourage people to help people. And I hope what you're saying is the best thing to do. I know punitively, you're not going to make people do it because they feel if they're going to jail, they're scatting, getting out of there. They're getting out of there. You have to catch them and you're not going to catch them like that. So thanks for your testimony.
Any other questions for our guest? Seeing none, thank you both for being here and for your time. We're going to go back into session. Representative Sapicki, we are on your bill.
Members, there's a lot to unpack there. We've had the Good Samaritan law in place since 2015. And in 2016, Tennesseans died. And in 17, Tennesseans died. 18, 19, 20, 21, 22, and 23, Tennesseans continue to die under the hope that somebody will do the right thing. That lady's child and her sister aren't coming back. Now, you heard a presentation by this gentleman back here, and he put a number on people dying. Well, you know what? You can look at them, and there's the face of people who are dying. They're children and family members. A lot of the data that was given today is skewed off of public, people that are found in public that you're not going to render help to. The data that we see is these deaths are happening in the back room with the drug dealer, are happening in the back room with somebody who's handing out drugs, getting them high and selling them. Let's make perfectly clear here. This bill is not in opposition to the Good Samaritan law that we will hope and pray. And there's two ladies behind me that are hoping and praying that somebody would have done the right thing for their children and sister. Hope and pray is not going to help the people of Tennessee that are dying. In the bill, Mr. Chairman and members, all it says is that a person commits an offense who knowingly fails to seek medical assistance for an individual who the person knows or reasonably should know is experiencing a drug overdose. Empathy, ladies and gentlemen, caring for our fellow man and woman in distress. We have laws in place about protecting children from child abuse. Why not helping the people that can't help themselves, who are laying there dying, and the people choose not to help them? This is a very tough situation, Mr. Chairman and members. I understand that. But I can tell you this. If we don't try something else on top of the Good Samaritan, I guarantee you that gentleman will come back next year and tell you how many more Tennesseans have died. Is it worth a chance to try to change that tide? Only you can decide that, and the members of this General Assembly. But the one thing I wanted to do today, Mr. Chairman and members, is I wanted to put a name and a face with those 3,000 people. And I deeply heartfelt because I could not imagine what they go through, and nor do I want to experience it with my children. Mr. Chairman, I'll try to answer questions the best I can.
Thank you, Representative. First on our list is Chairman Hulsey.
Thank you, Mr. Chairman. And Thanks for your effort, Chairman. I appreciate it. I have some real fundamental differences with this. But I sincerely mean that when I say I appreciate you pushing the line. The first thing that really troubles me is the only other place people can be charged criminally for failure to act is with the child abuse. But of course, in that particular case, you don't have criminal activity going on other than the perpetrator. It's not this setting. Second thing is, I think you'd have a real huge problem in court when you take a defendant that didn't call 911 and he's on the verge of overdosing himself. I mean, when I was in law enforcement, every one of these scenarios that I bumped into had 1, 2, 3, 4, 5 people who were all stoned, who were all out of their head, who were all on the verge of passing out. To expect one of those persons to make a judgment call that's sound, I think is really stretching it. And I don't know that you would ever be successful in that. There's another piece of it that troubles me a little bit. If you had 3 people and one of them overdosed and died, I'm not sure anybody other than a medical person would be able to read how close somebody is to death. How close they are, if they are in peril, in the sense of losing their life. I could never tell. I call 911 when I got to someplace that I got a call on there because I don't know. I don't know if they're asleep. I don't know if they're just on the verge of dying. But if you have 2 that did not call and the third one dies, and you charge these 2 for not calling, does the family then now have an avenue to turn around in civil court and sue for a wrongful death because they did not report? Those kinds of things really, really trouble me with the bill, even though I applaud your effort.
Mr. Chairman Halsey, I'm not going to get into a debate with you about criminal issues because that's not my forte. I'm going to trust that the judgment you're going to make on this bill is based off of many years wearing a law enforcement badge. I will say that the assumption that the issue of are they in the right mind to make the phone call, I could argue the same point on the Good Samaritan law. Are those still 2 in the right mind to make the phone call to call for 911? This is a complex issue. I don't know if there's an easy answer because I think if there was an easy answer, somebody would have ran that bill a long time ago. I think this is a convoluted mess we have in our society right now. And Chairman Halsey, when things get personal to you as a representative, you will do everything you can in your power to try to rectify the situation. Now, it's up to this committee in criminal justice to decide if this is the right path forward. It may not be today, but at least these 2 ladies behind me got to say their piece and put a face with that statistic that was given to you by a foundation. That's what we need to focus on, folks. These are real people dying in Tennessee. These aren't 3,000 here and 2,000 here. These are real people. Members, if this isn't a solution, I understand that. Okay, then what is? Because you're the Criminal Justice Committee.
All right, next on our list is Representative Johnson.
Thank you, Mr. Chairman. And I too appreciate what you're trying to do. I do understand that. And as I said, I have a good friend who lost her son in this exact same situation. But I think in hearing evidence based in research and data that when you take into account that these people in the room are also drug addicts, that expecting them to not be concerned about the law is a further stretch than them doing the right thing and understanding that there will be, getting that understanding out there that there will be deference taken to the fact that they tried to help this person. So I've always seen with human behavior, regardless of who's involved, that you get further by making it easier to do the good thing than making it harder. So I appreciate what you're trying to do, but I struggle to think that that is the best solution here with the data that we have. So thank you.
Representative Hardaway. He passes. All right, I'll defer to Representative Towns then.
Mr. Chairman, thank you. And like the body is saying, all of us understand what the attempt is to try to, improve and ameliorate this situation. I think what we long-term have to do with, thank you, with this scourge in our communities is more treatment programs, certainly, more health care for this particular area of people that are suffering, and in the community, people that can go out and counsel and get with these people and try to figure out how to get them into a situation where we can get them off these drugs. I'd love to see the drug man put out of business. I would really love to see that happen in this country, and it's not, and these statistics, Mr. Representative, are personal because we all know people. We all know people. This is not isolated in one part of the country or one part of the state. We all know people, and a lot of them are young people. They're young people, and it hurts, like Representative Shelby County was saying, it's just unnatural. You don't want your child to die before you. It hurts to the core. There's nothing you can do, but I say cry, pray, and try to move on with life, but it hurts, and the hurt doesn't go away. The hurt does not go away. These are real lives, real human beings, real pain. And we come to a quandary. Many times we, as members, we do things trying to ameliorate the situation, improve the situation, that because we are hurting and we're angry and we're upset about it, and it doesn't do what we really want done. But I know treatment works. I know things like that. And obviously prosecution on the other end, we got to stop the gap where this stuff is coming into our country. It's coming in by the truckloads. It's coming in by the boatloads. It's coming in by planes. We got to stop this stuff. This stuff has been happening since I was a kid and beyond, into communities. And now it's all over our country. It's everywhere. And the difference between you and me and young people, real young people, they know where to find it. You don't know where to find it, but they know where to find everything. The young people know where to find this stuff. They can go out and find the guns. They can go out and find the drugs. They can go out and find the countryman. They know where to find it. It's out there. They know where to find it. So as a group of leaders and lawmakers and citizens, we have to figure out the best approach to try to deal with it, because it needs to be dealt with. And like I said, your effort is to not be underappreciated or to go unnoticed, because we're trying to do something. I feel your frustration, your pain about it, because it's real. Mr. Chairman, thank you.
Thank you. Leader Lamberth.
I just want to thank you for bringing the bill. We've struggled with this for years here on when to criminalize inaction, but the people of Murray County are lucky to have you. And so I think the two ladies that testified today, our hearts and our prayers go out to all of you. I mean, everybody's saying the same thing up here. There's multiple different ways that we have tried to address this epidemic. First and foremost is to try to encourage every kid out there, an adult, just not to use this stuff. But once they go down that path, it can get very, very deadly. And so I thank you for bringing the bill, because it's a tough issue to wade into. And as you said, many have tried to resolve this issue before, unsuccessfully. It keeps getting worse. And so it's a bold move to try to even jump into this arena. I know it's outside your comfort zone even, but you did it for your people back home, and that's what we all came down here for. So I just wanted to commend you for even bringing the bill. Don't know what's going to happen today, but it is an issue that I think we have struggled with for a while on how to handle inaction, which is the most immoral thing you could possibly do, whether it's illegal or not. It's immoral to just sit there and watch somebody die. Somebody that may be your friend, somebody that may be, somebody you've spent time with, and to just do that is inhumane. But how do you define and criminalize that is so hard. But again, your folks are lucky to have you back home. I appreciate you bringing the bill. It's a difficult topic. Thank you.
Thank you. Thank you.
Representative Hardaway.
Thank you, Chairman. And I don't know if the sponsor wants to tackle this or not, or whether he wants legal to handle it. But what are the consequences now for failing to intervene, Good Samaritan, for if you're under the influence? What would the consequences be if this bill passes for failing to intervene, seek help, call 911 if you're under the influence of either drugs or alcohol, some substance?
If I understand the question is, what are the consequences now under Good Samaritan, and what would be the consequences if we do pass this bill on top of the Good Samaritan? Is that the question?
Yes, sir. A Good Samaritan that's under the influence.
Mr. Chairman, I'm sure legal could probably answer those questions a lot better than I could.
All right, we'll go out of session and hear from Legal Services.
Michelle Fogarty, Office of Legal Services. The bill before the committee has a penalty of a Class B misdemeanor. Under current law, there is no penalty. There is no duty on a person to render aid, except in the event they're in an automobile accident that they are involved in. You have to stop and render aid. There's a duty to report child abuse. But other than that, in our current statutes, there is no duty to render aid. Therefore, there's no punishment for that, for not doing that.
In either of those situations, is under the influence a defense?
No, sir.
And under the proposed legislation, would under the influence be a defense to failing to call for emergency aid?
The bill as written provides, the only exception that it provides is if the person refrained from seeking medical assistance because they reasonably believed that medical assistance had previously been summoned by another person.
So are there, okay, thank you, ma'am.
Any other questions for legal while we're out of session? All right, we're going to go back into session. Representative Hardaway, you have anything else for the sponsor?
Mr. Chairman, just that I'm still got a lot of questions. I think this bill at a minimum needs to have more conversation. And I see a lot of stuff that I think the carrot and the stick is really what we're discussing here, whether it's going to be all carrot or whether it's going to be carrot and stick. So I'm willing to get it out of sub for further discussion in criminal. I don't know where I'll be then, but I'm willing to. I think it has enough merit to get to criminal full, so I'll be voting for it.
Thank you for that, and thank you for the explanation from legal. And as you know, this is not my wheelhouse up here in the General Assembly, so I'm out of my element here, Mr. Chairman. And I know in the committees that I serve on, if there's an idea that maybe needs to be massaged a little bit by the committee and possibly some changes between now and full to alleviate Chairman Halsey's concerns and others, we are more than willing to try to accommodate those.
Well, what I was going to say to you, I appreciate what you're seeking to accomplish. It's certainly something that affects every one of us in our districts where we are, and I'm sure that we all could share the same story of someone that we've known or loved that has been through this. Some good things with the bill, some things that have raised some concerns or some thoughts. I was going to ask if you would consider rolling a couple of weeks and entertaining working on this through an amendment to see if we can get these concerns addressed, because I do think you have some really good things going here in the bill, but we might ought to consider seeking a different avenue to get to that destination.
Mr. Chairman, do you mind if I confer with the person who brought me this real quick?
Yes, sir.
Mr. Chairman, I work for the people of District 64, and my constituent has said that she would like to have the bill considered as is in respect to her sister.
Leader Lambert?
Move previous question.
Question's been called. Any objection? Seeing none, we're voting to send House Bill 1624 on to full criminal. Those in favor say aye. Those opposed? No. The noes prevail. The bill fails. Members, earlier today, we rode a bill down to the hill. And now she's back in the room. Item number 3, House Bill 2168. My Representative Littleton. You are recognized. All right. All right now. We got work to do here. You're in the proper format. You properly before us. You have an amendment code 13676.
That's correct.
You wish to proceed with that
I do,
amendment?
please.
Let's get that in the proper posture. All right, you're recognized on the amendment.
Thank you, Mr. Chairman. This specifies that an order of protection related to allegations of domestic abuse remains in effect during the appeal unless the order expires by operation of law.
All right. Does the amendment make the bill?
It does.
All right.
That is the bill.
That is the bill. Okay. Members, let's vote to attach amendment code 13676 on the House Bill 2168. Those in favor say aye. Aye. Those opposed? The ayes prevail. You adopt. We're on House Bill 2168 as amended. Any questions for the sponsor? Question's been called. Any objection? Seeing none, we're voting to send House Bill 2168 as amended on the full criminal. All those in favor say aye. Aye. Those opposed? The ayes prevail. You move forward.
Thank you, Mr. Chairman and committee.
Yes, sir. Representative Towns. Representative Gillespie.
Thank you, Mr. Chairman. I know this is out of order. I just wanted to welcome a college friend of mine, John Ike, who's in the room. If we could just say hello to him, please, and welcome to Tennessee.
Welcome. All right, item number 11, House Bill 2475. We will roll that to the hill. I believe he had to go present in another committee. That was by Representative Raper. Item 12, House Bill 1617 by Representative Ritchie. You're recognized.
Thank you, Chairman and Committee. House Bill 1617 is a bill that we'd started to chat on last week. What this would end up doing is simply changing, currently on the Tennessee sex offender registry list, depending on the severity of the crime, it's either a 10-year minimum sentence or lifetime. And then there's some additional circumstances that fall into place based off the age of the victim and things of that nature to where it would be lifetime. What this would end up doing is increasing that minimum from 10 years to 15 years. When we look at the repeat offenders, roughly about 32% of the folks that are on the registry commit another sexual crime in their lifetime. When we end up looking at the individuals that are on the Tennessee state or on the registry list, 42.7% of those individuals, approximately 42.7%, are on it for production of child pornography, and 38% is for traveling for prohibited sexual content. So what this bill goes to address is that void. We could have a 13-year-old victim, 14-year-old victim, and the individual would end up being required based off of the current law as a minimum. That victim could be 23 years old as still a very young adult with our current law. So this is just simply extending that minimum from 10 years to 15 years. And I stand by for any questions, Chairman.
That's 10 years from the time of release and not conviction. Is that correct?
It's correct. It's 10 years on the registry on there, and there's nothing retro. So it would only be after anybody convicted after July 1st, I believe what the date on there is.
Okay. Any questions for the sponsor? I've got Representative Fritz. Okay, he withdraws. Chairman Halsey?
Thank you. I usually right in the middle here and all over to one side. You know, the state of Michigan got sued on its sexual registry list, and they're better than we are. To me, it would be easier just to add 10 years to whatever the age of the victim is to cover that. The reason I say that is there is a portion of people who do re-offend and recommit and go out and do the same crime again. But there's another percentage that don't. And I know a particular case in my district where they went through everything they were supposed to. The state was through with them at the end of 10 years. They served their sentence. They did everything that was required of them. And now for 10 more years, they're going to be on a sexual registry list. To me, we end up making the list not an issue of what happened in the crime, but it almost becomes part of the penalty and the offense and the sentence. And I'd like us at some point in this committee to really revamp and redo the sexual registry list, but I just cannot see where 5 more years on the list is any really a benefit versus 10 years. Maybe you can explain that to me, and which is very rare for me to argue the other side of this.
Yes, thank you, Chairman. And so I'm purely looking at this. I had a situation to where an individual called me up and called me every name under the sun about an event that was taking place across the state of Tennessee, and was advocating on why children should be able to be at these particular events. And whenever the individual's name is on the phone, I typed that in, and this was somebody who was convicted of child pornography. And that individual was 13 years old. So if he had a sentence of maybe it was 1 year, it could have been to where he just pleaded to be able to be on the registry for that 10-year period. That victim is only 23 years old when they're coming off of that registry. So I do agree it is strengthening the penalty for doing one of these heinous crimes. So that's why I'm in favor of extending it 5 years. I spoke to our district attorney and we had talked about extending it to 20 years, but kind of that compromise was let's just move it to 5 years. I think we need to do everything we can to protect our precious children. I've got a young daughter, and I couldn't think if some vile, disgusting individual did something that would end up putting them on there, I'd want them to be on there for the rest of their life. So that's why I brought the bill.
And there are cases where they are on the rest for the rest of their life and should be. Exactly. I'm not an advocate of a soft approach on that. I just want it to be just. Is what I'm looking at.
Representative Hardaway.
Thank you, Chairman. And I'm kind of like Chairman Halsey. I'm just on the left side of that center line. The data or the evidence that you use in order to increase it 5 years as opposed to 20 or leaving it where it is it anecdotal or is it statistical, clinical research? Tell me how we got to the number that you got to.
So Representative ended up getting the 5 years. I sat down and spoke to our district attorney and said, well, what can we end up doing in these situations where we've got young victims that are between that 13, where they're still minors. And his recommendation was to just increase it up to the 5-year port.
So is that additional punishment, or does it allow them to get treatment for another 5 years, or we just want to observe them and make them prove themselves for another 5 years? Tell me why we're doing 5 years as opposed to 10 or 15 or lifetime.
So it is just to extend it 5 years. If one ended up running an amendment to make it longer, I would run that bill as well. I'm just going based off of what the district attorney had recommended, that an additional 5 years would be just.
Okay, so if at some point we went out of session and asked General Crump to explain it. He'd be able to explain it.
I have not spoken to General, whoever you mentioned. I'm talking about District Attorney of Blount County is who I spoke with.
Oh, okay. Well, I haven't spoken with him either, but I would like to hear from our representative from the DA's conference if he's available, Mr. Chairman.
All right, we'll go out of session. If you will, state your name for the record.
My name is Stephen Crump. I'm the Executive Director of the Tennessee District Attorneys General Conference. Representative Hardaway, our position on this, we're defer on this as a conference. We, as a conference, believe this is a policy decision that is best left to the legislature. All of those decisions that relate to the registry. Certainly, our members are called upon to enforce the provisions of the registry. And while individual district attorneys from time to time will be consulted by their local representatives and senators, that doesn't always mean that the conference takes a position. Because we represent the interests of all 32 district attorneys across the state, we have a series of bylaws that control when we can issue a public statement, either supporting or opposing a piece of legislation or any political position. We believe that strength in our numbers is important, and that when we speak, we should speak with one voice. And so the conference itself is very careful about where it lines up and when it makes a public position. And so Tennessee's district attorneys as a whole have not voted to support this bill. Doesn't mean we oppose it, just means we have not taken a position. We believe it's one that's left to the General Assembly.
And would you have any data to offer that would help us in reaching a decision?
Offhand, Representative, probably not. There may be information that we could get for you, but at this point, I can't. I'd have to go back and get it to you at a later date. There's no way I could get it for you right now. I don't have it now.
All right. All right. Thank you, sir. Thank you,
right.
Mr. Chairman.
Yes, sir. Thank you. Any other questions for our guest? Seeing none, we're going to go back in session. All right. Leader Lamberth.
Move previous question.
Question's been called. Any objection? Seeing none, we're voting to send House Bill 1617 to full criminal. Those in favor say aye. Aye. Those opposed? The ayes prevail. You move forward.
Thank you, Chairman and Committee.
Item 13, House Bill 1977. You are recognized.
Thank you, Mr. Chairman. House Bill 1977 authorizes any law enforcement officer certified by the Peace Officer Standards and Training Commission or the Post Commission, rather than only a full-time salary police officer, to detain a motor vehicle being operated on public roads, streets, or highways when the officer has a reasonable belief that the vehicle is is in violation of tinted window laws. So essentially what this does, Mr. Chairman, right now we have certain police officers that can and cannot pull people over for these violations, and this creates parity in the law. That's what the bill does.
Great explanation. Thank you for that. Leader Lamberth.
Move previous question.
Questions called. Any objection? Seeing none, we're voting to send House Bill 1977 on the full criminal. All those in favor say aye.
Aye.
Those opposed? Ayes prevail. You move forward.
Thank you.
Item 14, House Bill 1978 by Representative Capley. You are recognized.
Thank you, Mr. Chairman. House Bill 1978 would make burglary a Class D felony, and I stand ready for questions.
Any questions for the sponsor, Representative Johnson?
So, thank you, Mr. Chairman. I had someone give me an example of what could be included in this, and so I want to find out if that's factual, because it would make me think about this bill. So the solution I was given was, or the situation I was given was that if you were in someone, you were in someone's garage without permission, whatever. They had a garage refrigerator and you walked out of their garage with a Coke. Would something like that be included in this? Weird situation, but I want to see what happens there. Just to verify.
Mr. Chairman, I'm assuming that that would mean the person would be
Stole the Coke.
illegally entering the property owned of someone else. So yes, that would apply.
So that would be a felony.
It would be classified as burglary, which we are moving to a Class D felony.
Even though there's not a limit on the cost of what was missing. A lot of times, for a felony, it becomes over so many dollars, but
Again, entering someone else's premises without their permission is a whole nother subject. But yes, I guess is the simple answer.
let me make it a little more difficult. What if it was your next door neighbor who often comes over, but they didn't have your permission at the time, and you got mad at them? Could you press charges on this?
Mr. Chairman, I'm not going to play this what if, what could game. I'm just.
All right, Leader Lambert.
Move for his question.
Question's been called. Any objection? Seeing none, we're voting to send House Bill 1978 on the full criminal. Those in favor say aye. Those opposed? Ayes prevail. You move forward. If it should be recorded as a no.
Thank you,
please
Mr.
see the
Chairman,
clerk.
committee.
Members and those that have been here the entire time, I want to apologize to you. I'm very sorry, but I promise that we will get to you next week. All bills remaining on the calendar that were not heard today will be rolled to next week's calendar. We are adjourned.